Jesselyn Radack is director of a wonderful group, which I had a hand in inspiring, but it's gone way, way beyond my anticipation. It's called the Government Accountability Project. It's the nation's leading whistleblower organization.
But my story, how did I get this job? After graduating from Yale Law School here, I went to the Department of Justice through the Attorney General's Honor Program right after law school. I practiced constitutional tort litigation for 4 years, and then I became the ethics advisor. By then I had a couple of children and couldn't deal with the travel and deadlines of litigation. I needed a little stay-at-home time, so I did ethics policy. And I myself became a whistleblower because I was attorney consulted right after 9/11 when America captured its first detainee in the Afghanistan war, John Walker Lind. You may have heard of him referred to as the American Taliban. I was asked about the ethical propriety of interrogating him, and I was told matter-of-factly that he had counsel and he's an American. Your constitutional rights follow you outside of the country, and so I advised, as I did in pretty much every similar kind of case, that if someone is represented by counsel in the matter, you cannot interrogate them without their attorney. That was on a Friday. On Monday, the criminal division called back, saying that the FBI had ignored our advice, and what do we do now? Again, I said not to worry. FBI could be cowboys sometimes, and there were ways to deal with this by sealing off the interview and using it for national security or intelligence purposes, but not for criminal prosecution, which is exactly what the Justice Department proceeded to do. There was an atmosphere of hysteria after 9/11 that pervaded everything and everyone in this country. And that's not strange following a national security crisis. Our pendulum swings in a very nationalistic direction, and usually eventually swings back, but instead has swung even further. When the Justice Department continued this criminal prosecution, I inadvertently learned that there was a federal discovery order for all internal justice correspondence related to Lynn's interrogation. And the prosecutor wanted to know if he had everything. And he told me, I have 2 of your emails. Well, 1, no one told me about that discovery order. And 2, I had written way more than 2 emails. But being a naive 29-year-old, like my client Edward Snowden, I went and checked the hard copy file because that's how we kept things back then. When I went and checked the file, there were 2 pieces of paper in what had been an inch-thick stack. And my heart just fell to my stomach, and I was still in disbelief, so I consulted a very senior colleague of mine. I said, what's going on here? And he looked at the file and said very matter-of-factly, this file has been purged, which was inconceivable to me because the department was simultaneously prosecuting Enron and Arthur Anderson for destruction of evidence and obstruction of justice. So I called technical support. We had just gotten the internet about a year before. And I managed to resurrect more than a dozen emails, including the one documenting the FBI's ethical misconduct in its interrogation of John Walker Lind. It went beyond ethical misconduct into torture. If you remember the trophy photo going around the world of him blindfolded, gagged, bound to a board with duct tape with horrible words written all over him. It foreshadowed what we later saw at Abu Ghraib, but right after 9/11, nobody flinched. I wrote a memo to my boss, and I attached the emails. I made a copy for myself in case they disappeared again, and I gave her the memo, and I resigned. And I said, I don't know fully what's going on here, but I am not going to be a part of this because case, it wasn't about John Walker Lindh or sympathy for him in particular. It was about following the rule of law. The entire criminal case against John Walker Lindh hinged on the validity of the confession that he gave during the interrogation that I had advised against, in which he was denied a lawyer, and during which he was also subjected to enhanced interrogation techniques called torture that I am under a gag order and can't talk to you about. So I left the department, started doing something completely unrelated in the law, and the department continued to say, we never thought he was entitled to a lawyer. And I didn't believe the Department of Justice would have the temerity to keep saying that if my emails had in fact been turned over to the court. I tried to go to the judge, Judge Lindh. I didn't have standing. I was told I didn't have standing and it could not be heard. At that point, I went to the media because I could not live with the idea that someone else could be put to death because my email had not been turned over to the court. And the media, Newsweek in particular, wrote an article. The Lindh case ended in a surprise settlement. A couple of weeks later, he pled guilty to 2 minor administrative infractions for which he's serving 20 years. And I thought that was the end of this ordeal for me. But I didn't realize that by blowing the whistle, I had unleashed the full force of the entire executive branch. What did that mean for me? For me, it meant being under one of the first federal criminal leak prosecutions, investigations, and prosecutions, potential prosecutions. By the way, leaking is not a crime in this country. You have a First Amendment right to go to the press. And what I gave the press was completely unclassified. So I was put under a criminal investigation. The Justice Department referred me to the state bars in which I was licensed as an attorney. And for good measure, I was put on the no-fly list. Because surely, as a 7 months pregnant mom of 2 little ones, I pose a huge threat to aviation security. I was in the wilderness for a number of years, during which Bruce Fine defended me pro bono. I paid other attorneys upwards of $100,000 in attorney's fees, got a second mortgage on the house, was not bringing in a stream of income in a co-equal breadwinner house. So it was very difficult at those years. But it made me decide that I was going to dedicate the rest of my life to representing whistleblowers. So I went to work for the Government Accountability Project, GAP, where I represented whistleblowers who blew the whistle and did the right thing and faced retaliation like having their security clearance pulled, being demoted, being transferred to some meaningless position, stacking paper cups for $200,000 a year. At worst, getting fired. So in 2010, when I read that an NSA employee named Thomas Drake had been indicted, and had been indicted for espionage, which is one of the most serious charges you can level against an American. And from everything I could read, it sounded like classic whistleblower activity. I knew we had crossed a Rubicon. Tom was the first person against whom the Espionage Act had been used. It had been used first against Daniel Ellsberg 40 years earlier, the Pentagon Papers whistleblower. There were some 2 or 3 odd cases after that where it was used against people alleged to have mishandled classified information, and Tom Drake entered the history books as the 4th person. Since then, President Obama, for whom I campaigned, contributed to, and voted for, has brought 8 such Espionage Act charges, investigations, and prosecutions against people who were engaged in whistleblower activity. Tom Drake's case ended up crumbling beneath the weight of the truth because everything that the government alleged was classified turned out to be completely unclassified. In fact, it wasn't stamped classified until after it was seized from his house. a reason we have something in that piece of paper called the Constitution against ex post facto laws. But I guess we're not using that piece of paper that much anymore these days. But this unrelenting witch hunt against whistleblowers, I've always said this is really a backdoor war on journalists. And we didn't start seeing that until the subpoena of the AP, all the AP reporters, 23 different reporters' records, and a search warrant on Fox reporter Jim Risen's account. And he was called a co-conspirator for writing a story. Meanwhile, Jim Risen had been out here in the ether for a while under 2 subpoenas by Bush, and now a number of subpoenas by Obama, to try to make him testify against a source. And ultimately, I view this as part of a wider war on information going on in our country against whistleblowers and journalists and hacktivists and people who dissent from the government party line. And it is a fast track to having an Official Secrets Act, which we have lived without for more than 200 years in this country. I know you think I'm maybe exaggerating, but what does it say that the 2 biggest scandals of the Bush administration, torture and secret surveillance, the 2 people who blew the whistle on that, 2 of my clients, Thomas Drake and John Kiriakou, the 2 people who spoke up about that have been the only people prosecuted in connection with those scandals. The people who tried to stop it or condemned it. That's appalling. In the case of secret surveillance, we enacted what I call Enabling Act legislation afterwards in the FISA Amendments Act to provide retroactive immunity to the telecoms that had violated a law, every violation of which is a felony. Then Obama gave blanket jurisdiction to CIA torturers by looking forward, not backwards. So if my client, John Kiriakou, had actually tortured someone, he wouldn't be in jail today. Meanwhile, if you read the Washington Post today, you read about a new form of torture, one we haven't heard about because it's in a 6,000-page report by the Senate that the CIA is trying to bury. Because it turns out, even though everyone who did it has immunity, the people who authorized it, ordered it, wrote the covering memos, including my classmate, John Yoo, from Yale Law School. See, different people can come out of this place and do very different things. All of those people have immunity. Despite that, the CIA doesn't want that report to come out because we learned today, for example, not only were they waterboarding people, they tried to drown a detainee in a bath of ice water drowning of a human being. And why do we know about that? We know about that because of what are called authorized leaks, which is sort of an oxymoron if you ask me. But it's because US officials, who can only speak on the condition of anonymity because of the classified nature of this program, revealed that we did this. So they're trying to give you a little taste of what's in this report so it doesn't shock you too much. I think part of the war on terror and its aftermath has been inuring all of us, normalizing all of the bad behavior that we're engaged in. Yesterday, NSA, Chris Inglis, after the government begged the Washington Post not to name the country on which we were actually collecting every piece of content, of telephone metadata, one of the NSA employees went ahead and told us, it's Iraq. And Chris Inglis is not going to be prosecuted for espionage, nor is Leon Panetta, who did the same crime or committed the same crime that my client John Kiriakou did. John Kiriakou confirmed the identity of a supposedly undercover agent who had engaged in torture, rendition, interrogation. Getting thrown out by that. Leon Panetta revealed the identity of undercover intelligence agents to make a movie called Zero Dark 30. So while people who engaged in torture, like Jose Rodriguez, are enjoying their book tours, people like John Kiriakou, who is one of the most patriotic people I've met, and who has served his country his whole life, is in jail. And then, now we have Edward Snowden. It says a lot about a democracy that a whistleblower now has to leave the country. That is the safest way to make a disclosure without getting caught up in the legal system, is to leave the country to do so. What does that say about us? And, you know, for me, there are two attorneys in this country, me and Ben Weiser of the ACLU, who are publicly representing Snowden against a government that has the biggest microphone, biggest megaphone in the world. And all they can do is complain about maybe possible future potential harm with no evidence given. There's a reason that future harm is not actionable. I mean, you've probably studied that in torts, I hope. It's because it's very speculative and difficult to prove. And in fact, they've conceded the point that no harm has yet occurred by saying, well, there might be some kind of future harm. Just like they said, because of Tom Drake, NSA will go dark and the blood of soldiers will be on his hands. And as I said of Chelsea Manning, all this damage has damaged US for years to come. I went to that court-martial, which no one in the mainstream media did on a regular basis. The New York Times appeared twice for part of it, for a day. And the US produced not a single damage assessment. I would submit that the United States don't protest too much, but they don't stop. I mean, it really, this is completely out of control. And right now, I am confident that Clapper and Alexander and Chris Inglis's and the Brennans and of the world, people aren't going to remember who they are. But Edward Snowden will go down favorably in the history books and will be remembered favorably. And you have to decide whether or not you want to be on the right side of history or the wrong.